Hey everybody, John the Other here, obviously. And I have a hypothetical question for you. At least it's hypothetical for now. If you find yourself in a courtroom accused of sexual assault, do you think it would be relevant for your case if the jury knew that you had a previous and ongoing sexual relationship with the person who was accusing you? I ask because on January 16th this year, the Supreme Court of Canada convened to hear the Alberta Attorney General defend the overturning of a not guilty verdict in an Alberta sexual assault case. One of the questions asked by the Supreme Court was whether a jury's knowledge of the ongoing casual sexual relationship between the accuser and the accused in that case had any relevance in the prosecution and defense evidence at trial. As an example, according to the evidence of the defendant in the Supreme Court hearing in question, prior to the events which were claimed to be an assault, the accused and the accuser had gone together into the downstairs of the accused man's house, and he had said, "I'm going to fuck you." The female accuser is said to have smiled when she heard this based on the testimony of the man accused. However, according to her, she had no memory of how she responded. But this brings us to the question of context. If we are in that jury, you and I, and we hear that the man said this to a woman where there was no sexual relationship in his basement, we might get a strong impression that he sounds predatory, that he sounds like a creep. But what if the man who says this to a woman while they're walking down a flight of stairs to his basement, and we know that they have a long-term casual sexual relationship? Does that knowledge change the situation as we picture it? And is our new understanding logical, or are we indulging in legally forbidden assumptions? Because there are two legally forbidden assumptions in sexual assault trials, commonly called the twin myths. An accuser in a sexual assault trial cannot be assumed due to their sexual history to be a less reliable witness. The second assumption is that it cannot be suggested that an accuser consented to a sexual act due to that accuser's prior sexual history. The fact that it is obvious to people outside of courtrooms that a pre-existing sexual relationship makes consenting sexual acts more likely is not addressed in the current law, at least not yet. Bill C-51 is law in Canada now, and one of the things this new law did was expand the definition of sexual history to include communications of a sexual nature. This means that any record an accused person might have of consent to sex is not usable in defense evidence without first making an application to use it prior to trial, and of course letting the accuser and the prosecutor know ahead of time that that evidence exists, which gives them opportunity to modify the story of the accusation to bypass that evidence. I've mentioned this in a number of past videos, but now that it's law, a large number of innocent people are going to go to jail because the evidence they have of their innocence will not be allowed in court, or it will be allowed, but they will be maneuvering around it, and that's not good, to say the least. But the Attorney General of Ontario is not yet satisfied, because it's always possible that a person with evidence of their innocence might somehow be allowed to bring those records to court, and there might not be enough wiggle room for an accuser with a false story to modify their accusation, allowing for conviction of a factually innocent person. The Ontario Attorney General's Office has a plan to prevent both accused people from bringing their evidence to court and to prevent accusers who are not telling the entire truth to the court from accidentally offering evidence that a defendant might refute with facts. The video I'm about to play to you now is the Ontario Attorney General's representative outlining the Attorney General's plan to control the evidence.
I'm going to spend my brief time addressing how to control this evidence when, in fact, in the very exceptional case, it is admitted. It's also important, I say, to control the manner that this evidence is introduced, the manner in which it's introduced as the trial unfolds. This case is a prime example, unfortunately not a unique example, of what can go wrong if this evidence is not tightly controlled throughout the course of the trial.
What went wrong is that somebody was acquitted based on evidence.
We are proposing that this sort of broad relationship evidence, if it does go in, should either be reduced to an agreed statement of fact, or more practically and more likely, I would say, counsel should just be permitted to lead the evidence, to lead their witnesses through this evidence, strictly adhering to whatever description the trial judge lays out in his or her ruling.
What this representative of the Ontario Attorney General just said is that rather than witnesses, and I mean defense witnesses as well as prosecution witnesses, so the complainant, the defendant, and so on, do not be allowed to give their own testimony. Ask them an open-ended question and let them answer it. Instead, they be told a statement by either the defense or the prosecution, and then be allowed only to say yes or no. So they don't actually get to offer, the old conventional, do you agree to tell the truth, the whole truth, and nothing but the truth? No. They want to puppeteer the witnesses.
The hope being, of course, that if you leave this evidence in the hands of an officer of the court, it's less likely to be expanded.
You might be sitting there scratching your head going, why should we limit the expansion of evidence? Aren't we trying to get at the truth of the facts of the matter in a trial?
This is, I say, going to reduce inadvertent disclosure of further details.
Limit the exposure of the jury to details, or I guess as they would call them, inconvenient details.
And the bigger problem with that, of course, is it opens the door. It opens the door to sexual activity and sexual evidence that was originally prohibited by 276. But suddenly it becomes relevant because an issue has, because the Crown or the complainant has in fact put a fact in issue.
As a reminder, Section 276 prohibits evidence of a sexual history of a complainant being used to suggest that the complainant is more likely to have consented because of their sexual history, or their testimony is less reliable because of their sexual history. But this lawyer has just said that those two things which are barred by 276, thus the evidence of sexual history is barred by 276, might become relevant if a complainant inadvertently lets additional information slip out. So, notwithstanding those two prohibited lines of reasoning, if there's some other evidence suggested or some other conclusion not along either of those two lines, this lawyer wants to bar that.
I say leading witnesses through this evidence also reduces the opportunity for the accused to expand on this evidence, to repeat this evidence.
So if a complainant accidentally lets something slip out because they're testifying freely rather than just being led through their statement, do you agree this happened, yes or no, and that's your only availability of answer. So if a complainant lets additional details slip out into the courtroom, that might allow a defendant to point out inconsistencies, point out evidence where the claimed event of the assault or whatever didn't happen.
To place undue reliance on it, and from characterizing it in a way, perhaps friends with benefits or more coarse language.
I think she means F-buddies.
We have our proposals are in our factum in one draft charge. We say that the basic twin myth prohibition is not enough.
Now, 276, as expanded, is the prohibition, the keeping out of a courtroom evidence of sexual history, which now encompasses under the changes under C-51. That is now also evidence of communicated consent to a sexual act. So if you had like a voicemail saying, hey, let's hump, evidence of consent to sex, prohibited in defense evidence unless you disclose it first, allowing the prosecution and the accuser to move around it. And this representative of the AG is saying that's not enough. We want to puppeteer the witnesses. A lot of innocent people are going to go to jail. Lighthouse, which is a nonprofit that I'm the co-founder of, our job is to try to keep innocent people out of jail. And my partner in Lighthouse, Diana Davison, has written about this on the Post Millennial. You can read about that, link in the low bar. And if you think the work we're doing is worthwhile, maybe you could support us as well. We do need the help, and the work we do is stacking up. Thanks very much for listening, and as always, have a lovely, lovely day.